Hi, good afternoon.
Okay. Good afternoon, everyone. Welcome back to our third talk for this Legal Awareness Week. My name is Jie. And so today we are going to talk about the topic of landlord versus tenant. I believe that most of us here actually has signed a tenancy agreement, but some of us are still unclear on our rights and also our obligations, and even some of the clauses in our tenancy agreement. So today we'll be answering all these questions. And one of our speakers today will be Mr. Jason.
Hi, everyone. Thanks for joining us.
So basically, in answering all these questions above, tenancy agreement itself is very important. So before we start, if you have any questions related to today's topic, feel free to drop your comment or your questions at the comment section, and we will address it after our session end later. So
Yes.
tenancy agreement itself is an agreement arranged between the landlord and also the tenant, and it is not more than 3 years. Because once the agreement inside stated it's more than 3 years, it will be considered as a lease. So this tenancy agreements applies not only to like houses or offices, but also a small room itself. But there are still some conditions to be followed. But something to remind is, after you sign the tenancy agreement, it is strongly encouraged to bring it to this LHDN office to stamp the agreement. Because if it's not stamped, it will not be a legal document and it won't bind the parties, which means that next time if there is any legal action, this agreement cannot be considered as a evidence in the court because it's not legally binding and does not have legal effect. 所以呢，我们在提到这个出租协议的时候呢，其实要让这个租户使用或者是住在这个屋主的这个房屋里，但是呢，租户还是必须要遵守一些条例。有一点要注意的是，在双方签了这个协议之后呢，最好要拿去马来西亚内陆税收局呢去印花盖章，因为这样子你的协议才会有法律效力。因为如果你没有盖章的话，以后有什么事情，你不可以把这个文件拿去呈庭。Okay. So when we talk, so basically there is always something we call it as a standard tenancy agreement. So when we talk about this standard tenancy agreement, remember to check and make sure that all your terms that you want is included in this agreement. Because when you are drafting this tenancy agreement, you don't think like it's a standard one. Everyone also signed this agreement, so I just signed this agreement. But you have to remember that you can always add in your own intention inside. The landlord and also the tenant must always reach a mutual agreement on what you can do or what you cannot do during this tenancy period, and make sure that all these terms are inside the agreement, and this is very important to protect your future rights. 所以呢，在提到这个标准的合同的时候呢，大家可能会有一个想法，就是都是一个标准的合同，大家都是这样签，不如我也这样子签好了。但是其实呢，你在签订这个协议之前呢，你一定要检查、阅读以及确保你所有想要的这些条例都在这个合约里面，你才可以签名。因为每个屋主呢，跟每个租户呢，都有自己想要的条例。所以呢，双方一定要达成共识，确保这些条例在合同里面，这样子你才可以确保你自己未来的利益以及权利。So there are some of the important clauses that we need to include inside this tenancy agreement. These are the few examples. For example, early termination. Can I terminate earlier? If yes, is there any conditions or do I need to pay anything? Renewal. If I want to renew my tenancy agreement, is prior notice needed? Subletting, basically it means that allowing the tenant to rent the premise to other tenant. So is this allowed or not? So remember to add in all these clauses to make sure that to avoid any misunderstanding in the future. There are also some other clauses like minor maintenance and repair. Who has the responsibility? Who has to pay the cost? And one of the important clauses is forced merger, which basically means that in happening of what kind of events, it is not a breach of contract when either party fails to perform its duty. 所以呢，在提到这个协议的时候，有一些重要条款，这些是一些例子。比如我要提早终止我的协议，可以吗？我需要赔偿吗？或者是如果我要续约的话，我需要提前通知吗？或者是我要转租，就是基本上就是让这个租户有权利把这个房屋租给别人，这个租屋是被允许的吗？或者是在这个维修与维护方面，到底谁有责任？谁需要付这个费用？还有一个也是很重要的条例呢，就是不可抗力条款。这个条款呢，意思是指在一些不可避免的情况底下，如果有一方无法履行他的这个责任，他也不算是毁约。所以呢，这些情况一定要清清楚楚的列在协议里面。Besides, we will talk about what is the rights as a tenant. 你身为一个租户，你到底有什么权利？ First, these are some of the examples. The first one is the right of the landlord to repair and also maintain. For example, if the tap in your house is not functioning well, actually the landlord has the obligation to repair it. Or when we talk about the second one is maybe on the enjoy peaceful stay and also right to privacy. Basically, it's saying that the landlord cannot simply enter into the premise without any valid reason or permission. And one of another example is the right to security deposit. Basically, it's saying that the tenant has the right to take back the tenancy the deposit that you pay when the tenancy ends, in the condition that he didn't breach any agreement 所以呢，你身为一个租户，你到底有什么权利？第一，在一些维修方面的问题呢，其实租户有权利通知这个屋主，让这个屋主帮忙维修。接下来呢，就是屋主不可以随便进入这个房屋来就是去影响到这个租户的这些生活之类。还有一个呢，就是租户可以在合约结束之后呢，在没有毁约的前提下，拿回一开始付的定金。There is one important question and a very common question, especially now MCO is back. Many tenants will start to ask, can I choose not to pay rental because I also cannot open my shop, I cannot operate my business. Can I actually not pay? So as mentioned just now, this forced merger is basically the clause that says that if the event is listed in the agreement and it happens, if one of the party did not carry out the obligation, it is not a breach. We can actually look at this sample in this tenancy agreement. It mentioned that the events of the forced merger includes disease or epidemic such as coronavirus infectious disease, which basically means that if this event of disease has affected this tenancy agreement, you can choose not to pay. But if the agreement does not state such event, then legally you will still have to pay rental. I believe that most of the agreements that has been signed before this COVID-19 does not include this disease event. So it will be good when you are signing any contracts from now, make sure that this disease event is also included inside this forced merger clause in your contract. 所以呢，我们提到现在 MCO 已经回来了，很多的店务都不能开，也不能营业。所以在这个时候，很多租户就会问，我需不需要付租金？如果不要付租金，可以吗？这个呢，就得看你协议里面的这个不可抗力条款。这个条款简单来说，在一些不可避免的情况底下，比如打战，若有一方没有办法履行他的责任的话呢，它不算毁约。所以要看了这个情况到底有没有包括病症。所以再看这个情况，这个例子，这个荧幕上的例子呢，它是有提到病症的。如果这个病症已经影响到这个协议的话，其实呢，租户是可以选择不付租金的。所以呢，我相信现在大部分的一些合约呢，就是在 COVID 之前签的合约呢，都没有包括这个病症的这个情况。所以呢，从现在开始，如果你有签任何的合约的时候呢，大家可以多多留意看，到底这个不可抗力条款有没有包括病症这个情况。 Okay, next, let's see on the obligations as a tenant. Besides that, if you have a right as a tenant, as you have a rights, but you also have some obligations to be carried out. For example, you have to pay deposits, rentals, and also utilities fee on the time stated as stated in the agreement. And you also have to make sure that your premise is in a clean and also a safe condition. As the tenant, you have the obligation to maintain the original state of the premise. And one of the example is you also have, if you need any maintenance such as repair, you have to inform and also notify your landlord about this issue. 所以呢，在租户呢，他还是有一定的义务要去执行的。第一呢，你一定要准时的交你的水电费、你的租金，还有一开始你一定要付你的定金。还有第二，你就是要确保呢，你的房屋是干净的，是安全的，因为你有责任确保这个屋子呢是在一个干净以及整洁的一个状况。还有一个情况呢，是如果你需要维修你屋子里面的任何东西，你一定要通知你的屋主。So these are the obligations of the tenant. And now I'll pass the time to Mr. Jason to explain on the landlord and also some of the legal actions.
Yes, thank you, Natalie, for precise and very clear explanations on the rights of the tenant. Taking into account of the current situations, the pandemic, along the years, we receive a lot of calls and a general public who ask for advice as to how they going to face in terms of rental. I think it affect all small businesses or SME who have working their life off to earn a living, but somehow they are struggling at the moment because they struggle to pay rental, right? So then during this pandemic, we received a lot of inquiry as far as whether ones have to pay the rental or not, right? I think Natalie have clearly point out that whether it is all depends on what is stated under the tenancy agreement. Now, which is right. I mean, at the end of the day, it is what you agree, right, between the parties. But because this pandemic is just came in 2020, not mistaken, it's March 18, right? So that particular day, any tenancy agreement that signed before probably will have to stick with that tenancy agreement. If it is not mentioned any forced merger clause, then you have to leave it. It is not end of the day. I have seen sample in the past. The tenant will have to talk to the landlord. In this trying time, probably you can have 30% discount or 50% discount off the rental. And taking into consideration, especially the restaurant are unable to operate in full scale. However, you can still take away order, but somehow it doesn't probably couldn't give you the full effect of a restaurant. People are paying for that environment as well. So if you can't able to dine in, then it is very difficult for a restaurant, a proper restaurant to operate. Then taking into that consideration, you can actually negotiate with the landlord, right? So now it has come to another side of view. Another point of view is in referring to the rights of a landlord. Now, the following message is to share with all the landlords out there, right? Now, these are the rights. Number one, of course, you have the rights to take rental, right? Of course, that is your property that you rented out. It is your property. You have the rights to regain possession. But then this regain possession, this right only comes to you when the tenancy agreement expired. Okay, moving on, that of course you have rights to increase rental. Well, because this is your property, you have the rights to make the call how much you want to rent out to the particular tenant. And like I say, rights to receive rental and deposit. Now, if you look at the next slide, you will see the landlord obligation. All right. So what are the landlord obligation is contained? Probably you have, because you are the owner of the property, you will have to subscribe to or buy an insurance for that property in case of fire. The other thing is the maintenance. Some of these unit strata title, they will have to subject to payment of maintenance. Then the landlord usually subscribe to that, have to pay for the maintenance instead of the tenant. The other thing is quick grant and assessment. Okay, quick grant is 低税, or assessment is 门牌税. So both of this is borne by the landlord. Now moving on, it will be repair and maintenance of the premise. If you look at the premise, usually it's spelled out in the tenancy agreement who have the rights to not to repair and to repair what. So usually the structure, of course, wear and tear is exempted, but landlord will have to take care of the flooring structure because after all, it is your property. If it is not in tenantable condition, the landlord will have the duty to repair it. Now, of course, any property that you rent out, you will have to take a deposit, right? So that deposit, eventually, it will still a deposit. It is not a rental. When the tenancy expired, a deposit will have to refund back to the tenant. Now, these are the basic obligations, and we look at the next slide. So what if I want to terminate the agreement earlier? Now, this is very important because over the past years, during our practice, right, we always encounter clients approach us, brought forward a tenancy agreement. When we read the tenancy agreement, then we realized it doesn't indicate or give you a provision mentioned on how to deal with the matter of early termination. Early termination can be by the tenant themselves or the landlord. Now it is, like I say, it is all depends on the term stipulate in the tenancy agreement whether an early termination notice is required or there is not allowed early termination. So that is a difference because a fixed term of a tenancy, basically it is from one end to another. If it is a 1-year tenancy, means that you are not allowed. A fixed term means you are not allowed to have early termination. That can happen. If you want to put in a clause of early termination, usually you will have to give 2 months notice in lieu of the notice. Then you will have to pay that 2 months as a compensation. In some circumstances, if you wanted to terminate early, you will have to pay whatever rental up to the date of the expiry date. Yeah. So if I sign a tenancy agreement today, 1 year later, if I want to terminate tomorrow, I have to pay the entire 1 year tenancy. Despite that you wanted to leave, you have to move out from the premise, but you still have to pay the rental. That can be happen in a tenancy agreement as well. So indicate here, early termination is needed, whether as just mentioned, do I need to pay back the deposit? That really depends on the tenancy agreement, or pay anything as a tenant. So all of this, if the audience are listening, you can, and you have a tenancy agreement, you can actually have a flip through and see whether this clause is in the agreement or not. Now, because that really important to look at this particular term, because at this time, a lot of people would not sustain the FMCO. They are going to call, and we are going to face it on the 1st of June onwards. So it's about right time to look at the tenancy agreement, whether if you want to continue with the tenancy, with the renting the premises, whether I can early terminate or not, right? So you have to look at the tenancy agreement. The answer is there. All right. So we move on to the next slide. Now, as a landlord, well, if you the most tough situations or the least things that you wanted to face is that your tenant fail to pay you rental, right? So because that is ultimate aim. After all, for a tenant have a property for that matter, you just want to rent out and correct rental. But the worst thing happen is the tenant, don't pay you on time, don't pay you rental. So that it is where the stress come from. So what can a landlord do if you have no choice but then to regain possession of the property and quickly rent it to another person. But there are plenty of situations whereby the tenant are not corporate enough to return you a properties. There will be a situation where several months of rental are being tunggakan. That means it's been left out. It's not paid up to date. So these are the three actions that our law firms has normally do in recovery of rental from the tenant. Now, the first one is very common. It is a fast action. I'll just simplifies it. It is a distress action that a landlord can take, in the civil courts. So these are the specific. It's governed under Specific Relief Act, Section 7. Now, it is a provision that allowed a landlord to sue for the outstanding rental. Okay, so this order can be obtained in the civil court, and once you get the order, you can execute, and of course, it will then follow up with the remedy. What remedy that you have is I think the next slide will tell you. Of course, the sections 5.1. If you wanted to repay back your rental, please take note that should not exceeding 12 months. If you have anything more than 12 months, then you probably will not start the action under the distress. Instead of that, you have to sue via summon and statement of claims. But as of now, what I can share with all the landlord is do not have a rental outstanding exceeding 12 months, or anything less than that, you take distress action under Section 5 of the same act, right? So, like I say, if you get an order for a distress action, you can execute by way of writ of seizure and sale. This writ of possession first. Okay, let's talk about writ of possession. Writ of possession is basically an action that you can regain back your property. Now, how do landlord regain back your properties? Now, in a very practical way is you go to the premise and you see it's empty, you just take back the property, right? Which is very normal because it's your property. But it is not the right things to do. There is a few things that we have to take into consideration. That the first one is that the property has been rent out, right, to a tenant. There is an existing tenancy agreement. So in one form or another, you have to comply with the tenancy agreement. Now, if the tenant have breached the tenancy agreement and didn't pay you rental, well, you're entitled for the rental, but it doesn't mean that you can regain by just breaking in the premise. That will give a high chance that the tenant will counter sue you back for trespass and loss of valuable item in the properties. So what I would suggest that in that situation, even though the unit is empty, and unless because most of the time you can't confirm whether you can confirm there's nobody inside, but you can't confirm whether it is absolutely empty. If it's absolutely empty, then you can see, well, chances are you can regain by looking for a locksmith to open it, but it is not the right way. The legal way to regain back your property will have to seek a court order by way of writ of possession. So once the writ of possession granted, you have the court order, you can regain back your properties in a worry-free manner. All right. So let's say in another situation whereby the tenant, despite not paying your rental and also not leaving the premise, all right, so then we can execute by the next mode of execution. We call it a writ of seizure and sale. Now, writ of seizure and sale operate in this manner, whereby it is a surprise attack, means that you file an action under distress, the court will grant you an order for executions by way of writ and seizure and sale. So basically, if you obtain this order, the court bailiff will then take the matter before the premise, and then it is a surprise visit and tell the tenant, look, there is a court order saying that you own this landlord this amount of money. right? So what the bailiff going to do is to seal the unit. Seal means they locked up the unit that you are not allowed to operate. For example, if a shop lot you can't operate for that manner. So what the bailiff do is they will gain entrance to the properties and start doing inventory calculations on whatever valuable items in that premise. Now, after the inventory exercise has been completed and it comes to a mandate that the amount that they calculated, it is almost similar or equivalent to the amount of rental. Now, that lease will then be stick out from the shops. They give 14 days to pay the rental, filling which all these properties will then be auctioned off. The proceed of the sales will pay the landlord, right? So this is what we call writ of seizure and sale. Now, these are all the procedure that, as you can read it, so I don't read it for you. You have, in that, for that manner, you have to pay the deposit to the court. You need to meet the bailiff to start this action and so on. These are the remedy as far as recovery of rental is concerned. So let's look at the next slide. All right. So basically, as for the recovery of rental and whether you want to negotiate for a longer term renewal, I think Natalie also highlights some of the special terms in the tenancy agreement. It is always encourageable to all this tenant, being the bosses of the renting that premise. It is a good thing that you either go through yourself the tenancy agreement, or you can engage a lawyer to go through for you. Simply because in the past I've seen a lot of people who fail to review the tenancy agreement and they just sign it blindly. Now that tenancy agreement probably is just one of the sample or a precedent that pass on from one hand to another. I have seen some of the tenancy agreement who have absolutely nothing related to the case at hand. So it shows that somebody would just copy and paste a tenancy agreement and use it, adopt it to let the parties to sign, between the landlord and the tenant. So when things, turn up badly, so what happened is everything have to fall back to the tenancy agreement. So where is the rights? Where is the remedy for each individuals, right? For tenants or landlord, it is all have to refer back to the tenancy agreement. So it is very important, when the smooth ceiling of 1 year or 2 years tenancy, even to that effect of 3 years tenancy agreement, no issue. You can live with that. But then if something happens, something bad happens, so that tenancy agreement would be a savior. Everything will have to fall back to that, and we have to start reading and see what is my remedy. Can I terminate early? Can I not terminate early? Whether forced merger is there to cover in the current scenario, 1st of June onwards is MCO. So quickly look at your tenancy agreement, whether it's covered. If it's covered, then that means you are, you're not obliged to pay that rental at that time, because it is agreed by the party. But unfortunately, if it is not covered, then you will have to stick with that and continue the rental. So today's sharing is just a very basic touchings on the rights and do and don'ts on both sides, as far as the tenant is concerned and the landlord is concerned, right? But of course, there will be a much more complicated situation that we could not actually have enough time to share with everyone. For example, how about subletting and so on? Whether have the rights to sublet or not? What if I want to have a longer terms? Can I have 3 terms? Can I register the lease? How do I do that? How much is the legal fees and so on? Of course, there are plenty of things that we can talk about, but then I think we really run out of time here to go into deep. But then if anybody who are interested to know more, you can actually reach us by calling us or making an appointment with us. Yeah. Thanks. That's my sharing so far. Yeah.
Okay, thank you, Mr. Jason.
Yep.
Before we end today's session, we have a question from our audience, basically asking that as a landlord, if today my tenant is not traceable, I cannot trace him already. He already moved out from the premises, but before he moved out, he refused to pay the electricity and also the utilities fees. So what can the landlord do in these kind of circumstances?
Natalie, just now there was a breaking. You are saying that the electricity and the water has not been paid, is it?
Yes, but
And they
then the
leave.
tenant already moved out without informing the landlord. So what can the landlord do?
I think the few things that we can look into. Number one is whether there is enough deposit. You know, the utility deposit that you collected, right? Whether it's enough to cover. Now that is number one. If it is not, then you will have to look at the entirety of rental plus the utility. How much is the total outstanding? Now, I know it is a bit late to tell you to take note of the tenancy agreement. Usually, you have to trace the IC of the tenant, because we have clients who have encountered the same situation. When you put the address as in the premise itself, you can't trace the tenant anymore, and you don't have the tenant IC. Probably that is a mistake at the beginning. So that is very important for the next tenant that comes into pay. You need to have a photocopy of the IC. So as far as the IC goes, is the tenant last known address. Say if you want to take legal actions or you want to send a notice of demand, you can base on the IC address, because no point send a letter of demand to the premise, because the tenant is no longer there. Yeah. So that is the things that have not happened. But then if it happens that you didn't get the tenant, well, where is the tenant live? So probably you will have to take the outstanding from the deposit. If there is no deposit for you to take, then move on. Let's see how much is the total outstanding accumulated, whether it crosses 5,000. The reason that I give you a 5,000 benchmark is this. In Malaysia, you can actually take a private action, individual civil action against another person for a matter of 5,000 and below, right? Anything above 5,000, of course, you have to go to civil court and engage a lawyer to do so. Like I say, that what you can do to save costs. For commercial, if it makes commercial sense, if the total outstanding is more than 10K, you can actually engage a lawyer to sue. Yeah, we can conduct an IC search and locate and where it is. Then we can send a letter of demand, and you can obtain a judgment against that person. Yeah, that is how you recover. Of course, just now I have mentioned a few things. But for the monetary sum, it's not about regain possession. Monetary sum, it is another execution process. Yeah.
Okay, thank you, Mr.
Yes, thank
Jason,
you.
for
Yeah.
answering. So basically, remember when you sign the tenancy agreement as the landlord, remember to prepare all the documents such as IC to make sure that you know the identity of the tenant itself. So I guess today's session has actually come to an end. So through today's discussion, we can see that actually tenancy is very important to actually protect our future rights and also our obligations, all this kind of thing. So, and please make sure that don't sign your tenancy agreement blindly. Remember to check and make sure that you really understand the tenancy agreement before you sign that agreement. Not only tenancy agreement, but also all other contracts. Remember that you really understand the contract before you sign it. Okay, so once again, thank you very much to our speaker, Mr. Jason, for this fruitful talk today.
Welcome. Yeah.
And also not to forget all our audience who joined us today. We hope that today's talk can actually answer some of your queries. At the same time, just to remind everyone that MCO is back, remember to comply with the SOPs. Besides, please follow our Facebook page and our Instagram, Jason Kong & Co., to get more legal updates on our Legal Awareness Week, as we will be having more talks and also legal updates. And now, we will also post a Google form in our comment section there. Do fill in the Google form if you have any feedbacks for us, and also let us know what are the topics that you are interested in. So stay tuned, stay at home, and stay safe. Take care. Thank you, everyone.
Thank you. Bye.